Hello, item number 3,
my lord. I am for the petitioner, my lord.
the identical matter is fixed
No,
tomorrow.
my lord, not at all identical, not
For
at all
tomorrow.
identical.
I
My lord,
have the
let me
prayer.
place my case, my lord.
My lords, it's identical, if I may, my lords. Good morning, my lady. This
Yes, my
matter
lord,
is
please.
listed. Your ladyship is seized of these matters tomorrow. Identical
This
matters,
is
and
your
now the
lordship's
Supreme
order.
Court has also made clear
Identical
that your
prayer.
ladyship will hear all the issues that my lady has specified in her set of three orders. So now everything is before my lady, and an identical petition, Kiran Deb Sarma, WP 22447 of 2025, is pending before my lady, which is listed to be heard tomorrow.
Petition, my
And
lord.
I will
But
also
I
have the
appear,
pleasure
Lord,
of being there physically, my lady.
but I appear for the state. Lord, I believe, Lord, all these matters can be taken up together tomorrow.
This is the
My lord, I
prayer.
have my objection.
But I am appearing for this school service commission.
This is the prayer. If lordship fixes, this is the same prayer.
My lord, your lordship, no, tomorrow.
Yes, what is the matter?
My lord, the matters is, my lord, your lordship has held, my lord, the division bench of our High Court twice and the Supreme Court that no tainted candidates would be allowed to participate in the recruitment process in the written examination. If any candidate slips through the net, my lord, the commission will ultimately reject their candidature after verification. My contention is, my lord, though a list has been published which only contains the name of the candidates, my lord, who have Weimar mismatch. Their name has been published as tainted candidates. My contention is, my lord, none of the names who have been appointed after expiry of the panel are being included in the list of tainted candidates. Now, why I am saying expiry of panel is falls under the list of tainted candidates. Well, straight away come to this, my lord, the judgment of the division bench in the first round, when, my lord, our division bench set aside 26,000 appointments. My lord, page 260.
Page 260.
Page 260, my lord. Paragraph 14. Paragraph Roman 14. My lord, paragraph 335. It is paragraph 335 and paragraph, my lord. So
XI?
yes, appointments given to persons submitted, and, my lord, XI. Appointments have been given to persons after expiry of panel. So, my lord, this is one category which falls under the tainted. Now, my lord, a writ petition was moved immediately after the advertisement was issued that no tainted candidates will be allowed to participate. But the coordinate bench allowed our prayer, saying that no tainted candidates should be allowed to participate. Very interestingly, my lord, the state and the commission preferred an appeal, saying that no tainted candidates should be allowed to participate. Now, my lord, the division.
Preferred an appeal where?
Before the division bench,
All right.
the tainted candidates should be allowed to participate. My lord, kindly come to paragraph, my lord. No, I less from, my lord. Paragraph. Paragraph 30 onwards, page 21.
No, but then the Supreme Court has made it clear that the tainted candidates will not be allowed.
Yes, my lord. Why I am placing this, my lord? Candidate not be allowed. Why they might say, my lord, expiry of panel. Why I am saying so, my lord? This is important. This is the division bench judgment, and nothing else. My lord, truth has an ugly habit of raising its head, and when it raises its head firmly, it engulfs and demolishes any system which is founded on deception and corruption. In the earlier round of British,
Don't read. Don't read. Tell me what.
then, my lord, kindly come to page 23, paragraph 32.
Yes.
Paragraph 363, Roman has classified three categories of candidates who can be described as tainted candidates. Persons who have been outside the panel, my lord. Thereafter, persons.
Expiry of the panel.
Expiry of the panel. Now, my lord, my contention is the list, and, my lord, your lordship is already aware of the 28th August and 29th August Supreme Court order, where it has been Supreme Court has stated that no tainted candidates would be allowed to participate in the recruitment process. Now, my lord, kindly come to order of the Supreme Court at page, my lord, 61 of the record.
Yes.
WBSSC has also tried to justify the extension of the term of panel.
Yes.
Said above, the time period of 1 year specified in Rule 21 of the Rule 21 for destruction of remuneration coincides with the time period specified for validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teachers for 19 and 11 were made after expiry of panel. This is illegal and contrary to the rules. Reliance has been placed on the orders of the High Court, which clearly the cases of rank jumping, where the High Court directed to appoint candidates after expiry of validity of the panel would not have any significant impact. Now, my lord, clear that after expiry of panel, nothing. Now, my lord, kindly come to paragraph 10 of my
The
petition.
panel, the list of tainted candidates that has been published, there is no mention of
No,
anybody.
because there is no mention of under which category they fall tainted.
Yes.
And my lord, these petitioners submit on oath that none of the names which included in that list contains after expiry of panel. That is why all of these addition of party applications are floating in before your lordships. My lord, now kindly come to paragraph 10 of my writ petition. This is at page, my lord, page 12. Lord, I am reading this sub paragraph. It is pertinent to mention.
Yes.
It is pertinent to mention herein that the panel for classes 11 and 12 was published on 27/11/2017 and the same expired on 27/11/2018. And the classes for 9 and 10, it was published on 12/3/2018 and the same expired on 12/3/2019. It is further pertinent to mention herein for both classes 9, 10 and 11, 12, 2 rounds of counseling had been conducted within the tenure of the panel. There were 7 or 8 rounds of counseling. After second round, all counseling and appointments were made after expiry of the panel. And my lord, the Supreme Court has categorically stated in paragraph 31 that counseling and appointments made after expiry of panel is illegal, and the act of the commission in trying to extend the panel is also bad in paragraph 31. Now, my lord, my prayer before your lordship is the list, they should include the candidates who have been appointed after second round of counseling for 9, 10 and 11, 12, and the list should contain the category under which they fall. Otherwise, this will contain.
Category means?
My lord,
Category means what?
category means, my lord, whether they are falls under rank jump or.
All right. All right. All right.
Except court orders.
And why this is urgent, my lord? The 11 in the Supreme Court, it was stated that nobody would be allowed to sit in the written examination. They have been allowed. They have been now called for verification. Their verification, they have not been rejected. Now 9, 10 results have been published. They have been included. So, my lord, in this way, now they will say interview will be done. Now my right has accrued. Nobody has challenged it. Again, my lord, this chaos will happen.
All right. Then in that case, commission's list was placed before me on one occasion. Is the list there?
Well, there is an important aspect in the matter which may have.
I want to see the list once.
Lord,
I have the list. My lord,
Let me see once.
Lord, in that list it was not there.
Do you have any other list?
No, no, no. Only one list.
Only
What you
one
not-
list.
Huh.
Where is the names of the candidates who were called for counseling after expiry of the panel?
My lord, I just tell you. Lord, if your lordships kindly see the judgment of the Supreme Court.
No, I want to see the list. The list, it must be there in that bundle, isn't it? Is it there, Mr. Bandyopadhyay? The list was there, isn't it? Yes, please let me see. What are the heads over here? Heads are mentioned.
Well, heads were mentioned in the very Supreme Court judgment itself.
Where? Which portion? 292?
325 onwards, your lordship will get the status.
292 is the list.
325. 292 is the list.
List of all candidates as per notice number such and such. All candidates, what does all candidates means? How many candidates participated in the examination, or what does all candidates mean?
All candidates who have been ascertained to be tainted.
Why have you not mentioned it? List of tainted candidates?
325 kindly sees onward the status of each candidate has been tainted.
325. when you publish a list, you mention it as, I don't know, commission. You are not there for the commission.
No, no. My lord, we have given a notice on 30th August 2025. There we have
325, list of
three-
tainted
two-
candidates
two
with
times
nature of taint. OMR issue, OMR issue, OMR issue.
out of panel is mentioned from 340.
Rank jumping,
Also mentioned as indicated.
out of panel,
340.
340, 341, 342. OMR issue. Is there any candidate where it is mentioned called for interview or counseling after the expiry of the panel? Nobody is there. It cannot be. It has to be because court has found that there are candidates.
That finding,
Mission.
what my learned friend
To
has
that extent,
relied
Mr.
on,
Bandyopadhyay was
but
advancing argument.
that has been diluted by the Honorable Supreme Court in other paragraphs, where specific on the basis of the CBI report, a table has been, my lord, copy pasted.
Wait. Yes.
Well,
Senior
can I
Mr.
make-
Bandyopadhyay.
Yes, can I make a submission? Kindly, my lord, come to my lord, the page 56.
Yes.
Page 56 of the writ petition. Lordships will find me at paragraph 24.
No.
The impugned judgment refers to the following statistical report submitted by the Wbssc before the High Court. This is the OMR issue, rank jumping, alleged irregularity. Alleged irregularity, so and so, percentage. Then we'll kindly come to paragraph 25. In the written submissions filed on behalf of the Wbssc in the court, two tables have been furnished. Table 1 pertains to the candidates who are the jump ranking or were appointed despite not being in a panel. Their details are as under this. Then we have table 1, table 2. The losses will find there no kind of a. But those who are found tainted by the CBI, on that basis, this was prepared. This was done. They are the tainted persons have been found by the CBI in their report. Now, others have not been found as a tainted person. Now, if the
Where
others
are the candidates who were found to have been called for interview after expiry of the panel? Is there anything mentioned anywhere? Because the
no,
court's
it was
order
not.
mentions about that.
It was not the case of anybody before the Supreme Court. Today, a new case is being made out. Things.
Our Supreme Court has remanded the matter here. Whatever was under remand is different. This is absolutely fresh writ petition that has been filed. And the allegation is that candidates who were found to be called for interview or verification or whatever, it was after the expiry of the panel. This fact of expiry of the panel was taken note of by the division bench of this court, and it was affirmed by the Supreme Court. I want to see the list which contains the names of those candidates who were called for interview after expiry of the panel. This is what the court wants to know.
My lord, just in the gist, I submit. After the counseling of third panel, up to counseling of the third panel, this list was, the panel was valid. But during 1 month, 1 year, 6 months, there was an interim order on the panel. Thereafter, so many matters have been moved. There, the court has allowed to work on that. I have the orders also. Now, therefore, Miller, the counseling process has begun 1, 2, 3, 4, 5, 6, 7, 8. But it is not that these panel candidates have committed any fraud or any other things, like the tainted candidates. Now, therefore, Miller, the up to 8 council, this process was continuing. It is a part of the process. And they have been, Miller, still now, they are not being treated as a tainted. Therefore, they have been asked to appear in the examination. They have been asked to, Miller, appear, those who have succeeded to appear before the interview.
The division bench of this court found the appointments given to persons after expiry of the panel to be an illegality. That is what is mentioned in paragraph 335 of the division bench's judgment.
Yes,
Right? So
right.
if an illegality has been committed, that cannot be perpetrated.
But that has been merged with the Supreme Court order, that finding.
Exactly. After merger, this becomes valid. The division bench's order gets validated.
Now,
Paragraph,
my lord,
Court,
we will
paragraph
go by the Supreme Court's order, my lord.
yes, certainly.
My lord, anyway, my lord, whatever the way your lordship decide, we don't have the difficulties with that. My lord, this is our stand, we have said so.
Your stand is clear. Please show the candidates who fall under category 335 XI of the division bench's judgment.
No, we have not treated them, this panel, when the counseling was going on, when the process of counseling was going on, we have not treated after third counseling, the panel has expired.
Appointments.
And they are still continuing in the employment in view of the Supreme Court's order. Their appointments also have not been challenged by them.
Submission was made before the Supreme Court when this matter was being heard. Kindly see the first line of paragraph.
Their employments have not been challenged.
Line of paragraph 31.
Supreme Court judgment.
Supreme Court judgment, page 61 of the writ petition. First line.
Same submission.
These very submissions were made before the Honorable Chief Justice Justice Khanna as his lordship came on. And kindly see, WBSSC has also tried to justify the extension of the term of the patent. It was justified, tried to be justified, it has been rejected as illegal and bad.
well, this has to be read with 46.
যেখানে একবার বলে দিয়ে this is illegal and contrary to the rules.
Yeah, what?
It has to be read with 46. Right.
Yes.
Found to be tainted.
No, there is a difference
Not
between
specifically.
for candidates not specifically found to be tainted.
Right.
Now, there are separate tables which have been provided in the very judgment itself. If Lordships kindly have a look at that. Just may I say, well, this will have a there are large number of persons. Even we are getting salary. We are also, my lord, providing employment. Kindly look at this. No, may I just say? Kindly visual. May I kindly visualize? My lord, kindly look at from a point of view of a very surface that any illegality is tainted. That argument is possible. But there is a likelihood when Lordship look at the entire judgment, the Honorable Supreme Court used the word tainted for exactly categorized persons.
Supreme Court.
Now that exactly categorized persons, they lose any right to participate in the further selection process. Now that categorization was done by the Honorable Supreme Court on the basis of fundamental two things. Thing number one, 4 reports filed by the CBI because CBI scanned all the OMR sheets. And thing number 2 was the affidavit filed the SSC. What exactly happened was that there wasn't, I take it, 1 year validity of the panel. Absolutely true that after that date, there has been counselings up to 8th counseling. That is true. So if Lordship asks a yes or no questions like a mathematics, then the answer would be yes. If starting, there are a couple of counselings which were after the 1 year expiry, correct? But does it mean that those persons who were appointed and who never participated or never been part of this Weimar, that corruption part, are they tainted, or whether the Honorable Supreme Court wanted them to be included in the tainted or not, that this has a larger issue. We also need to, may I say very honestly,
Why don't you get it clarified by the Supreme Court what the court wants?
the Supreme Court has clarified. That is the reason the Honorable Supreme Court completely dependent on the basis of the list by the SSC and allowed all of us to get the salary, and we are serving.
You are serving
Yes.
because of the benevolence of the commission.
No, we are serving because, correct, I take it that benevolence of the,
Please, somebody is there
Malad,
online.
I-
You can make submission. Otherwise, you will be scolded by somebody else and
in
not by
fact,
the court.
it is our life and death. It is our life and death.
Milord, may I make, Milord, one line submission, Milord, on behalf of the state?
All I say this, I have only one thing to say. This is an extremely important issue. Malad, may I only get one day? Only one day. All I sought that tomorrow, so that we can also take all preparations. Because there are large
Milord,
number of
kindly read
matters.
Milord paragraph 46. This everything has to be Milord boiled down in paragraph 46 of the judgment. 46 of the judgment.
After expiry of panel, and also those who submitted blank OMR but obtained appointments must return all remunerations and benefits received by them. Now read paragraph 45. This is the division bench judgment. Now read paragraph 45 of the Supreme Court judgment. This is at page 67. The last question, your lordship.
Yes.
The last question relates to the relief and whether it requires any modification. We had no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates whose appointment must be terminated, and they should be required to refund any salary payment secured since their appointment is a result of fraud. These amount in cheating, we have to see for justification to all candidates. So, my lord, kindly read this with 363.4 and this paragraph. Nothing remains, my lord. All these things were already submitted and Supreme Court.
Let me hear what the AG has to say. AG.
Milord, I have got a very short submission to make. But in my very humble understanding of the judgment of the Supreme Court, Milord, possibly, Milord, there were three categories of, Milord, candidates who were found to be tainted, which are, number one, Milord, the candidates who were guilty of rank jumping or who were the beneficiaries of rank jumping. Number two is out of panel appointment. And number three, Milord, where, Milord, the manipulation of OMR sheets had happened. Now, Milord, these are the, Milord, three broad categories of persons who were found to be tainted. Now, Milord, my learned friend for the petitioner today, Milord, wants your lordships to, Milord, add another category. The category being those who were appointed, Milord, after expiry of the panel. Please consider, Milord, whether, Milord, this can be done or not. Assuming, Milord, the allegations of the petitioners have any substance, please consider, will it not amount to adding to the judgment of the Honorable Supreme Court? The division bench had considered it, the Supreme Court had considered it, and Milord, this category of persons, Milord, in my understanding of the judgment, was not declared specifically to be tainted. Therefore, according to me, Milord, today, Milord, my learned friends cannot come out and try to make out a fourth category. Tomorrow somebody will come out and find out a fifth category. This cannot be added to the order of the Supreme Court. At this stage, Milord, this is my submission, subject to, Milord, consideration of, Milord, the judgments of the Honorable Supreme Court in its entirety, number one. And number two is, Milord, as your lordship knows, Milord, the Supreme Court has, Milord, fixed a timeline. The timeline being 31st of December 2025, which that process will be completed. Now, Milord, these kinds of petitions will pour in. This is expected that these kinds of petition, Milord, with some injury, this way, that way, will be portrayed before the court, seeking an interference. Milord, please allow the process to go on. If my learned friends can make out a case, that can be taken up, Milord, subsequently. But as of today, Milord, my understanding of the order of the Honorable Supreme Court is that, Milord, this fourth category was not treated as to be a tainted category by the Honorable Supreme Court, based on whatever, Milord, the report which was filed by the CBI, both by our division bench as well as the Supreme Court. Let the process go on, we'll come back better prepared and address your lordships on this issue, These are my submissions for the present.
Bench of Justice
Milord,
says,
can I make one submission? Milord, can I make, kindly allow me? Just
Yes,
allow me. Milord, the petitioners here, they have secured 34 and 24.
yes.
Most unsuccessful persons.
My lord, I have
Let's
stated I
assume,
have been called for verification.
not call for verification.
Yes, called for verification.
Very nice. Allow me to make submissions. Otherwise, my lord will be annoyed with me. You are interfering. But the 34 and 24. First of all, by no chance, even if the petition is allowed, they are not getting the employment. Their only purpose is, since we have not got it, no one will get it. This is one. Number two, Miller. Paragraph 46 has been said about tainted. Tainted. Tainted is on the basis of the CBI report, it is tainted. Now, let's assume for the argument's sake, the appointments were illegal. Illegal doesn't equate to tainted. Tainted is based on a certain facts discovered by the CBI. The paragraph 46 has said about tainted, not illegal. There is a demarcation of these two. But this point needs to be argued. These points have to be argued. This is initially I am pressing this point. Then we'll file affidavit. Lordships will decide.
And they will continue and they will again get there. My lord, two things.
1 minute. 1 minute.
My lord, I
1 minute.
can show you one judge, one order. Just hand it over to Mr. Samim appeared. Now, one case, they are obtaining one order, another case challenging. Kindly take the order of 30th August 2023, give it Justice Vishwajit Basu's judgment, Salma Sultana.
Yes.
And see, the petitioner participated in the first SLST for recruitment of assistant teachers, so and so, sponsors, so and so. The petitioner was a wait-listed candidate in the sex selection process under the general female category. The petitioner alleged that in compliance with the direction passed in Sitabuddin, etc., a list of candidates was published by the West Bengal Board of Secondary Education, whose appointment letters were generated as per the recommendations of the West Bengal Central School Service Commission. And from the said list, the petitioner for the first time came to learn the commission had recommended her appointment in the post of so-and-so, and the board had issued the appointment letter. The petitioner thereafter has filed the incident paying appointment in the post she was recommended. Mr. Samim, learned counsel for the submit that it is astonishing as to how the petitioner was recommended for appointment in a particular school when she never appeared in any council. He further submits that 8th phase of counseling was done after the expiry of the life of the panel. Can you see? Then Dr. Patto, learned counsel for the commission, submits that petitioners was notified to participate in the counseling through text message in her mobile phone, number of which she disclosed in her online application, but she did not turn up. He further submits that the intervening COVID-19 pandemic did not allow the commission to complete all rounds of commission councils within the period of the life of the panel. Mr. Bhattacharya, learned counsel for the board, submits that the appointment letter was issued to the petitioner on the recommendation of the commission by the so-and-so. Mr. So-and-so, I have heard the learned counsel for the at length and have perused the materials on record placed before me by the respondent authorities through their respective reports. The commission in its report has specifically stated that merit position of the candidates was not compromised in recommending the appointment of the petitioner. Holding the 8th phase of counseling after the expiry of the life of the panel gets justified for the situation which prevailed all over the world on intervening COVID-19 pandemic. The mode of notifying the candidates about the date of counseling through mobile phone in the member so-and-so, as has been argued by Ms. So-and-so, the possible candidate has missed such communication cannot be ruled out altogether. The petitioner was found to be eligible for the appointment but could not join in the process. Well, then the direction is that he should be there. Therefore, this 8 months counseling was already 8 times counseling was taken into consideration by your lord, one of the coordinate bench of your lordships, and their number of reasons one of the reason was COVID-19. But we can't go on, Lord, on just pure technical questions. We have to consider about the facts and circumstances of the case. More specifically, I am submitting, Lord, these persons who are not found to be tainted. Paragraph 46 is clear, that is only a tainted. Let's assume an order is bad. Order is bad doesn't mean it is tainted. Tainted where fraud has been committed.
Very well. Tainted, untainted, you please place the list of candidates who were appointed after the expiry of the panel. Whether
Correct.
they'll be treated as tainted or not tainted, it
That
will
will be
be
decided.
seen later on.
My lord, appointed
My
under
lord,
the
my
second phase of counseling for 19 and 11, 12. That has
Just one thing, madam.
Or the division bench's order, whatever is there is there. Appointments given to persons after expiry of the panel. Let the names of these candidates be placed before the court.
Well, I have
My
absolutely no difficulty for that.
my lord, that also
Maybe
that
the
also
court
has
is
been
not going
covered by this
into-
paragraph 31.
There is a note, a mention in the division bench's order, which has been affirmed by the
My
Supreme
lord,
Court.
only one
My
thing,
lord,
one
only-
This appointment
why
be given.
I am saying so. My lord, why I am saying so? In the
Well, we will see modified, rectified, clarified, whatever.
why I am saying so.
Let the list
The
come.
second phase, because my lord, two things are important. The list of candidates appointed after expiry of panel and date of publication of the panel and date of expiration, the expiration of the panel. That may also be produced before your lord.
1 minute.
Otherwise, they will say my
1 minute. OMC tested. And then for 1 minute. I want the list, Mr. Bandyopadhyay,
yes,
from
my lord,
the
yes.
division bench's order, page 260, 335, 335,
Roman 9.
Roman 9, appointments given to persons who were not there in the panel. 10, appointment given to person submitted blank OMR. Appointment given to persons after expiry. Persons placed lower in rank given appointments. That means rank jumping.
Well, accepting this group regarding the appointment after expiry of the panel, other all categories have been treated as a tainted, and their names have not been sent.
All right, the list that has been placed.
my lord,
That
this-
is
your lord-
categorized list was there.
This list.
my lord, this is your lord.
1-9,
Kindly
Roman
see.
10.
So we have
I've
given the
given.
list.
This is little
My
thin
lord,
one. It
what
can
tainted possibly is a very extremely, my lord.
Uploaded in the website, madam. But what thing, madam, in mostly mandal, madam, pass the order. Till date, they not publish it. Full list is necessary. Madam, this Salma is considered by the Supreme Apex. In the volume.
Mosui Mandal is not taking up, Mr. Samim. The Mosui Mandal is not being taken up now.
But you refer the Salma.
No, refer the submission? Give the order first.
OMR issue
And
not in the panel.
place that list.
OMR issue,
Rank jumping.
then out of panel.
9, 10 and 12 is
Out of
already there.
panel.
9, 10 and 12.
9, 10, and 12 there. So 11 is not here.
Rank jumping.
only
11.
11 is not there, my lord. And
All
they
right.
have admittedly they are protecting those tainted candidates.
এগুলো বলতে হবে, সব
We may
live আছে।
consider the what tainted is
Um,
really what.
Yes, I see 9, 10, and 12 is there in whatever you have handed over in court. I do not know whether this is in the public domain or not. But then 11 is not there in your list also. Prepare a list and place it before the court.
Yes. All right.
With all details.
And my lord, one thing, my lord, at the earliest, because the verification, everything is going on, they will accrue their rights.
Now, if even it is stopped, you are not entitled to get for verification.
Yes, my lord.
Yeah.
One reply-
You have got only 32.
My lord,
Hmm.
6,000 to 7,000. If these candidates
Nahin
go,
dewane?
automatically
Dewane
will
hoy.
come into
20,000 will go.
See one thing, the appointments of the year 218 also stood nullified by the Supreme Court in 2025. So it's not that it cannot happen. Rights may accrue, and then the court is here to see whether it's correctly accrued or not. So the court is taking care.
My lord, also
I
not
would
keep
like to
this.
see the yesterday's judgment, whatever is there, so that I understand. I understand.
My lord, also, my lord, kindly keep this, my lord, point open that whether, my lord, they can at all, my lord, come before this honorable court at this stage. My lord, at the time of, my lord, publication of the notice, they did not challenge, my lord, put this omission at least, that this is not there before the honorable court.
Where are you?
They're not yet,
based?
my lord, published the OMR sheet.
We are, my lord,
Brother, kindly keep the maintainability point open, my lord.
by the order of
They
this
did not
honorable court.
publish the OMR sheet.
Well,
So, my lord,
till date, no OMR has been published.
Now,
my lord,
your
details.
lordship,
Then you participated in the test again.
yes,
They hiding
Alright.
it, although
Yes.
there's a
Let us
specific
see what
order of
happens.
yes,
publication
at least,
of
my lord,
the
kindly keep this.
Maintain,